So triggering review requires first establishing federal involvement and second showing that there's going to be an undertaking. And that undertaking has to have the potential to cause an effect on historic properties. We couldn't review all agency undertakings. That would be ridiculous. If we didn't have this second part of the law, we would technically have to do a Section 106 review if an agency wanted to purchase office supplies. So no, we only do a review if the undertaking has the potential to affect historic properties. This doesn't mean that you need to know that there are historic properties out there when the project is going on. If it's the type of thing that could affect National Register listed or register eligible resources, if they do exist once someone has an opportunity to look, then there has to be a Section 106 review. Is the project going to mess up buildings, dig up soil, require painting a facade, change traffic patterns in a neighborhood, or otherwise alter a landscape? The effects don't have to be direct, knock it down, dig it up effects. It could be that they impact the viewshed. There might be auditory effects. It could cause changes in the land use or traffic patterns. At this early stage of the game, we're looking at the type of activity and impact potential. If there's no potential to affect a historic property, then you stop there. There doesn't need to be any further review. There have been decisions that have clarified what type of activity may not cause an effect on historic properties. For example, if the federal government takes property by eminent domain, this has been held not to be an undertaking. But subsequent federal decisions about how to use the land afterwards will be undertakings subject to Section 106. But getting rid of land, releasing it from federal control, is an undertaking because by releasing the land from control, historic structures could be harmed now that they're outside the reach of the National Historic Preservation Act. You would have to look at your action and consider the case law to see if there's precedent as to whether or not what an agency is doing is an undertaking that affects historic properties. If the undertaking is the type that would affect historic properties, then we can let the games begin.